Assalamu alaikum, good evening, welcome to the Ask Aman Livestream. Today we've got three key issues that we'll be looking at, but before we go to the issue, just want to quickly play you a short video.
Aman Solicitors Advocates. From our offices in London and Luton, we represent clients across England and Wales. We specialise in civil and commercial law and litigation, divorce, child custody, contact and family law, all areas of personal injury, accidents at work, trips and slips, family and business immigration, nationality, asylum, deportation and detention law, wills and probate, employment law for employees or employers, charity law and disputes, public and regulatory law. Our professional and committed legal team will provide you with a first-class and competitively priced service. Aman Solicitors Advocates, your firm of choice.
Welcome back. Before we start the show, I'm just going to play a quick disclaimer. Thank you very much. So to introduce today's show, we will be having three main issues to talk about. Firstly, just to go through them in order, we'll be looking at the case of Shamima Begum and the decision to effectively reject her appeal from being allowed to come to the United Kingdom to take part in the proceedings to challenge the deprivation of her citizenship and to look at the broader issues regarding that. We'll also be looking at the case of Wembley Masjid or Wembley Mosque regarding the powers of trustees to exclude people from the mosque. When can they do them or how can they do them? We'll be looking at that. And we'll also be looking at the power of the Home Office to refuse applications for settlement based upon the historical misconduct or bad conduct of people regarding their character, conduct or associations. Now, these are matters which all three of them can affect many of us in different ways. I'm waiting for my colleague to join me regarding the case of the immigration matter, which we were going to start with in the first instance. But while we're waiting for my colleague Saad Said to join me, I will start with regard to the case of Shamima Begum. Now, just a bit of background. Clearly, the case of Shamima Begum is of the young girl who went along with two of her friends from East London to Syria, where she joined Daesh and effectively became a part of that whole setup out in Syria. Once they were defeated, she was sent a decision that effectively deprived her of her citizenship. And once that decision was taken by the then Home Secretary Sajid Javid, then she could not return to the country because she ceased to become a citizen of the United Kingdom. And as a consequence of that, she was now, according to the Home Office and according to Sajid Javid, she was entitled to the citizenship of Bangladesh from where her parents hailed by operation of Bangladeshi law. The problem, however, was that the government of Bangladesh have made it very clear that she is not entitled to the citizenship of Bangladesh, and therefore, as a matter of fact, she is stateless. She has no state. The United Kingdom has revoked her citizenship. The government of Bangladesh have said she cannot, or she's not their responsibility. So being stuck in a camp in Syria, she decided to challenge the decision to revoke her citizenship. And that decision entitled her to a right of appeal to what's called the Special Immigration Appeals Commission. This is a court where secret evidence will be submitted, so the public do not get to see this evidence because, in the opinion of the Home Office, that evidence is so sensitive that it would harm the national interest or relationships with other governments and so on. It would harm national security, basically. So there are special arrangements with things such as special advocates who can look at the evidence and try and challenge it without ever being able to discuss it with people like Shamima Begum, but it could be anybody else for that matter, who is effectively being denied citizenship on that basis. And the appeal before that court normally requires or would allow you to turn up and argue your case, answer questions, and try and challenge the case against you. Of course, prior to that, you've got to be able to, in confidence and in a clear way, be able to communicate with your solicitors and barristers and so on, to be able to understand what you're alleged to have done, what you must do to challenge the evidence, and so on. So it's all about being able to effectively take part in the proceedings to prepare for the appeal and so on. Now, in this case, it was agreed that she couldn't get an effective hearing because where she is and the circumstances of the refugee camp that she's in, the SDF, the Syrian Democratic Forces, who run that part of Syria. So what happened is that the case has a complex history. I don't want to bore anybody with too many details, but there were technical legal issues upon which some she succeeded, on others she lost, and there were proceedings in what's called the Divisional Court in the High Court. Also, there was an appeal against the decision of SAIC in the Court of Appeal. So it got to the highest court in the land, and basically that court decided that the Court of Appeal, the second highest court in this country, had got this case wrong because they did not have sufficient evidence before them to effectively have a legal basis for disagreeing with SAIC's assessment, the first court, the court where you can put in secret evidence, and that the Home Office decisions on things such as national security are not to be heavily interfered with because the court is not as well placed on merit to deal with such issues, because the Home Office has a wider array of evidence and skills available to it, namely the security services in particular, as well as other evidence. And it's ultimately a political decision, and if the public, who are supposed to be protected by the governments of the day, if they don't like the measures that are being taken, such people can be voted out at a general election. So effectively, political accountability lies with the politicians and the Home Office in this case, and therefore the court should lightly interfere in what's called traditional public law basis, not on some sort of merits-based jurisdiction. And there were complex discussions regarding this matter before the court. And effectively what happened was that the Supreme Court took a decision which was, in the eyes of many commentators, harsh on the procedural aspects, because this is not about whether or not Shamima Begum should keep her citizenship or be allowed to come back in. It's on the basis of how she can properly challenge that decision. And part of that was to apply for a visa to come to the country to give evidence, and that was rejected because she was a security risk to national security, which could not be adequately addressed or managed. And that's where we are. Now, my colleague Saad Said has joined me, so I'm going to pause there and introduce him into the discussion before we go further. Assalamu alaikum, Saad. Thanks very much for joining me.
Wa alaikum assalam. It's good to be here. Thank you, Bisharat.
Okay, so what I've just outlined with regard to Shamima Begum is the legal background. I may come back to this subject in a moment, but what I'll do is we'll potentially ask you to introduce briefly the subject matter of your conversation first, which is the case of any immigrant. It's an immigration type theme here where they qualify for settlement, but the Home Office use a power called paragraph 322 of the immigration rules, 322(5), subparagraph 5, to deny people settlement who would otherwise be entitled to it. If you want to give us a brief introduction, I'll go off screen and then I'll perhaps ask you a few questions, and we may well return to the case of Shamima Begum after we've completed this.
Okay, thank you very much. So just to give an introduction to the viewers out there who may or may not be familiar with certain aspects of immigration law. When anybody ever makes an application either to enter the UK with a visa or to remain in the UK to extend their visa, aside from the general legal requirements that they need to meet in order to get that visa, there are what we call the general grounds of refusal, which outline general reasons which the Home Office can refuse any application for. And they include reasons such as if the person has got a criminal record, or maybe otherwise if their presence in the UK may not be conducive to the public good, or it could be things such as maybe they owe some money to the NHS, or previously they've taken the Home Office to court and not paid their legal fees, things like that. So these powers which the Home Office have are general and apply to all visa categories, no matter what kind of immigration rule you apply under. So in my particular case, what happened was that I had a gentleman who had initially come to the UK as a student, and then begun working in the UK and had built up 10 years of residence. And people who have been in the UK for 10 years continuously and lawfully are then allowed to apply for settlement. And he had applied for settlement,
Yeah.
saying to the Home Office that he had completed those 10 years continuously and lawfully. And the
Okay.
Home Office completely accepted that. But what they said is that when he had previously applied to extend his leave, and not the visa prior to that application, but 2 or 3 visas before, he had made certain declarations that he had earned a certain amount of money. But when the Home Office checked his tax returns, then the amount he'd declared to HMRC didn't tally with the amount that he had declared in his previous visa applications. And effectively, what the Home Office was saying was that he had told them in some visa applications he's earned a certain amount, but when he declared his tax returns to HMRC, he had declared he'd earned a lower amount, and so he had not paid the correct amount of tax.
How did they view that? So
Sorry?
you're saying that the tax on the tax returns was different to that stated upon the visa application or the application for settlement, and hence the Home Office alleged that that was dishonesty or bad conduct. Is that right?
Yes, that's right. So this is where paragraph 3225 comes in. And what the Home Office said is that he had behaved in such a way which was dishonest. And so through his conduct, or maybe through some associations, or through his character, he wasn't entitled to remain in the UK any further. And on the basis that they alleged that he had either deceived HMRC by declaring a lower income than he had earned, or by inflating his income in his visa applications where he had obtained extensions of his visa before.
Okay,
Points.
Is this common in terms of allegations of dishonesty or misrepresentation to get a visa, or in this case to get a settlement or indefinite leave to remain? Is this sort of a common thing with the sort of cases that you and your colleagues deal with?
Yeah, so obviously when I was representing one of my clients who had fallen foul of this, I began doing some research, and I found out, yes, that we're talking about thousands of cases where people have done a similar kind of thing, where they have declared a certain amount of income in their previous visa applications to obtain extensions and remain in the UK, and then similarly at the same time they've declared lower incomes to HMRC, either to avoid tax, or maybe, as the Home Office were alleging, then the lower amount declared was actually their true income, so they were lying to the Home Office. So yeah, I mean, in terms of the figures, we're talking about a few thousand of people, so it is quite common, yes.
Okay, so what happened when your client was refused the indefinite leave to remain, the settlement visa? You appealed to the first court. What did that court decide? In your client's favor or against him?
Yeah, that's quite right. So, as you will know, Bashara, that when somebody who applies for indefinite leave on the basis of having acquired 10 years residence, if the Home Office decide to refuse their applications, they are given a right of appeal to the first tier tribunal. So, obviously, my client exercised his right of appeal. That's right. This is the Immigration and Asylum Chamber of the first tier tribunal. As we know, there are different chambers, but the Immigration and Asylum Chamber is the one that deals with immigration appeals. So he exercised that right of appeal, and by exercising his right of appeal, he was given the right to have an appeal hearing, where he was given the chance to go to court and show the judge, an independent judge, that he had not been dishonest. Unfortunately, he didn't succeed, and the judge found that he had been dishonest. That wasn't the end of the matter, though, because once the judge found that he had been dishonest, the judge also had to decide whether the Home Office was right to actually refuse his application using this power, because the power was discretionary. So the judge went in to consider that.
When you say discretionary, sorry to interrupt you. When you say discretionary, you mean that it wasn't an automatic requirement to refuse, even if you have that in your mind that there's been dishonesty, you still have to balance everything up to decide, is it so serious, is it so bad that refusal is justified, right?
That's exactly correct. Yes, that's exactly correct. And when the judge went on to do that and perform that balancing act, then the judge decided that the application was rightly refused by the Home Office using this power. So ultimately, my client failed in his first appeal. But then what we did after that is we challenged the decision of the first tier tribunal, and we appealed to the upper tribunal. So for those of you that work in the immigration field, they'll be familiar with there are two tiers of the tribunal. There's the first tier and then the upper tribunal.
It's like an immigration appeal court, right?
That's correct. So these are the immigration and asylum chambers. But yeah, you're right. They all deal with immigration appeals. And if you lose your appeal in the first tier tribunal, you can then seek permission to appeal to the upper tribunal. And that's exactly what we did. And we obtained permission to appeal to the upper tribunal. And then we went there and argued that our case, that the judge who had dismissed my client's appeal in the first tier hadn't effectively followed the law properly, because the judge had failed to apply this balancing act properly, or had failed to consider certain parts of evidence properly when deciding that my client was dishonest. And there were some other technical legal arguments as well.
What happened then? Give us the conclusion.
Yeah, so sadly, again, we lost in the upper tribunal. But what happened at that time was that there were a number of these cases. As I've talked about, the Home Office found thousands of people in the same situation. So there were a number of these cases going through not only the first tier tribunal, but the upper tribunal at the same time. Some of them were going through the route of appeals, as I've described. Some of them were going through the route of what's called a judicial review, where they were challenging the lawfulness of the decision of the Home Office. And eventually, some of these cases went up to the Court of Appeal, so that the Court of Appeal could decide what is the exact approach, the proper legal approach to deciding a case when the Home Office think that this power applies, and they think it applies to a particular person who's applied for settlement or any extension of their leave.
What did they decide? I mean, just summarize for us, what did the Court of Appeal say is the correct way of doing this?
Yeah, so the Court of Appeal basically said there is more or less a two-stage approach, which is exactly what I've outlined. So the first stage is to decide whether or not the person who's made the application has been dishonest. Yep. And if they have been dishonest, to decide whether generally their application should be refused using this power or not. And as you said before, when deciding whether this power should be used or not, they have to weigh up everything. So not only what happened, but weigh up the length of time that the person has spent in the UK and the strength of ties and connections that they've built up and any family that they have, all sorts of factors. And that's what the upper tribunal and the first tier tribunal didn't do in our particular case. So
then you appealed that again, and of course this is now going to the second highest court in the land, which is the Court of Appeal Civil Division. So what happened? Did you succeed? Did you get in? How did the case progress in the Court of Appeal?
Yes, so actually what happened is, before we could get to the Court of Appeal, or as we were going to the Court of Appeal, this other decision of the Court of Appeal, where they set out the correct legal approach, came out. And the upper tribunal then acknowledged that they hadn't actually followed the proper procedure in my particular case. So they wrote to me and they asked me, what do you want us now to do in your appeal? Do you want us to reconsider it? And if so, how? So I made representations to the upper tribunal saying that the approach set out by the Court of Appeal hadn't yet been followed. And I asked the upper tribunal to set up a new hearing so that they could reconsider my client's appeal by following the correct approach as they should have done initially.
So what happened?
Yes, so the upper tribunal redecided the case, but without an actual hearing. And in doing so, unfortunately, they went on to make some more errors of law. And that meant, again, I had to do a second subsequent appeal to the Court of Appeal, on the basis that, again, the upper tribunal had not followed the correct legal approach as was set out by the Court of Appeal in this other case. And I'm glad to say that very, very recently, in the last couple of weeks, we have succeeded in that appeal. And in fact, we managed to succeed in that appeal in the Court of Appeal without a hearing taking place, because the Home Office, when they reviewed the case and decided whether they're actually going to try and defend it or not, accepted that the upper tribunal had not followed the approach properly at all, and the errors made by them were so obvious that there was no point even trying to defend the appeal. So we agreed a settlement, and we got the appeal allowed by consent.
And did you get a barrister to do the paperwork and the proceedings before the Court of Appeal? Did you do them yourself? How did that work?
Yes, no, throughout this whole process, I was representing my client myself in the first tier tribunal and in the upper tribunal, and I also made the application myself to the Court of Appeal, which included not only lodging the application but drafting all of the grounds and the legal arguments as well. So I'm pleased to say that I had involvement all the way through on my own. We didn't really need any barrister because I was well aware of the issues and able to put forward all of the legal arguments.
A one-stop shop. And in terms of the appeal that you succeeded in, what about costs? Because it's quite expensive to take these appeals to the Court of Appeal. What happened to your client's costs?
That is indeed correct. So in the order that was agreed between me and the government legal department, it was agreed that the Home Office would pay my client's legal costs because the error from the upper tribunal was so grave that it was agreed that the appeal was actually going to be allowed by consent. And as you're aware, in any case in the Court of Appeal, it is usually the case that whoever wins the case gets their legal fees paid by the other side. And because the government legal department accepted that our appeal should be allowed, they also accepted that they should pay my client's legal costs.
Okay, so an excellent result all around. And next step is to have another go. Did the Home Office agree to grant him a visa, or is there going to be yet another appeal hearing?
Yeah, so now we've agreed that there's going to be yet another appeal hearing in the upper tribunal. Obviously, this time we hope that the upper tribunal is going to follow the proper legal approach, do things properly, and that we're going to get the right result. But we are waiting now for the next stage.
Okay, thanks very much for that, Saad. So when I started, we were talking about the case of Shamima Begum and the House of Lords, so the Supreme Court decision in allowing the Home Office's appeals against those parts of the case which Shamima Begum lost and dismissing Shamima Begum's cross appeals, i.e. the appeals on points that she lost on. So just to summarize for you what that means. In a case where your citizenship is taken away from you, you're entitled to make an appeal to a special court known as a Special Immigration Appeals Commission. Secret evidence can be used, and there are special procedures that apply. Because she was abroad, and this is how very often the Home Office do take decisions of this nature, she could not attend court because she was outside of the country and no longer a citizen of this country, and therefore she had to try and obtain a visa to get here. She lost that challenge, and ultimately the Supreme Court backed the Home Office position more so than a position which was more friendly to appellants. Now, what's interesting and perhaps worrying amongst many legal commentators is what's called the deference, or, not second-guessing the Home Office. And the power of depriving people of citizenship over the years has got easier and easier and broader. So originally it used to be, except for things like fraud or deception, because anything obtained by fraud or deception would never be yours, including citizenship. The Home Office originally would use the power in the last 40 years for certainly those who are naturalized could have their citizenship revoked in certain circumstances, i.e. you were not born a British citizen, you naturalized yourself, then there were certain circumstances, particularly where you were engaged in activities which were affecting the vital interests of the United Kingdom, things like that. So it's quite a difficult and challenging legal test to prove. But as things developed, then people who registered as British citizens, i.e. those who were entitled to it as of birth, they began to become subject to the power of deprivation of citizenship. And then dual nationals. So effectively, it's the laws that were passed. This is what really needs to be looked at. The courts in the jurisdiction of this country, in the legal setup of this country, are not really heavily, interfering, or will not heavily interfere in cases of this nature. And dual nationals effectively means that if your grandfather was born in a country such as Pakistan, Bangladesh, India, wherever it may be, and you've never been to that country, you don't even necessarily speak the language of that country, by virtue of the fact that your father was entitled to that citizenship, or your mother, and that you would be, as a matter of the law of that country, you could lose your citizenship, and effectively you would not be entitled to come back to this country to live here, even though you may have your children here, you may even have grandchildren here. This is how harsh and tough it is. Many people will say, well, look, if you make your bed, you've got to lie in it. If you go and join groups like Daesh, that's tough, and that may well be right. But the process in challenging the decision is the key thing here. The law is a tough law. It's a very harsh law. Many people will say, many academics and commentators have said this. But what it effectively means now is that the Home Office was basically wait. If they think you're up to no good, and when you're out of the country, if the Home Office think that it's conducive to the public good, i.e. in the judgment of the Home Secretary, Sajid Javid before and Priti Patel now, if they think it's in the public good on your behalf, the public's behalf, that a person should be deprived of their citizenship, they would then do that, make that decision, and effectively you are left high and dry. And today it's people like Shamima Begum. Today it's people who are linked to Daesh. But once a power is obtained by politicians, this can be used in an ever-expanding area or number of ways, because conducive to the public could be that you hold political opinions potentially in the future which would be deemed to be not conducive to the public good. Who's to say where the line will be drawn? Now, clearly, politics changes. If you look at what we've gone through in the last decade and a half, we can see that intervention of the state in many areas of people's lives and liberties is ever so increasing. It's increasing, and hence power such as this, the wisdom that I would agree with would be that the courts should take a tougher line in scrutinizing and evaluating decisions and allowing people to take full part in such proceedings. One of the most interesting examples here is that prior to 2005, if you were born in the island of Ireland, that is Northern Ireland or the Republic of Ireland, you'd be, certainly in Northern Ireland, you'd be a dual citizen. You'd be Irish and you would be a British citizen. And there have been numerous convictions for terrorism offences, people who are actually carrying out terrorist activity in Britain, in the United Kingdom over the last 40, 50 years. I'm not aware of a case where any such person was stripped of their citizenship and told, well, look, you can go to Northern Ireland, you can go to Ireland. We don't want you here, because you wouldn't be stateless. So there is a feeling that the way that the Home Office have treated Shamima Begum is different to how they've treated other people engaged in terrorism or terrorist-related activity, or have potentially supported an organization which is proscribed, i.e. a terrorist organization. And this has some credibility, because unless people who are being convicted now were born after 2005 in Ireland, they would still be dual nationals by birth. That's what I understand to be the legal position. After 2005, there were some changes made which don't make it automatic. So these are questions which do leave many people scratching their heads. Ultimately, of course, everybody's safety matters and safety has to be protected. But where do you draw the line between the rights and the access to justice, which should be fundamental in any society for people affected by decisions such as losing their citizenship, vis-a-vis saying, well, no, this is so difficult, we're not going to allow that. Because we know that hundreds of people have come back from Syria and many of them have been managed. There was discussion about control orders and things of that nature being used, but ultimately that argument failed. And as I've said, if your father, grandfather was born in a land and you've not been there, you would, by virtue of them being a citizen and you being able to get citizenship of that country, be subject to this difficulty. So it's a very difficult and challenging sort of area of law, and let's see what happens ultimately, because at the moment the case has been now of Shamima Begum has been stayed because she can't access a proper hearing process. Until she can, she must remain where she is, not a citizen of this country and not welcome to the citizenship of Bangladesh. I'm not an expert on Bangladeshi law, but by all views, as I understand, senior politicians in Bangladesh have said she's not welcome and not their problem. And to conclude this, if the British government wants to deport people who are terrorists because they shouldn't be here, there is a paradox here that you would want them to go somewhere else. And that, as many people have said, for somebody who was born and brought up and grew up in this country, seems a tad bit peculiar and harsh. But anyway, we'll leave that as it is. My colleague Adnan Mahmood hopefully will join us now. We'll have a further discussion about a very interesting development, or an interesting legal situation regarding what is known as the Wembley Masjid or Wembley Mosque case. It's a dispute which Adnan will tell us about. He can join us, and I will ask Mr. Saeed perhaps to just take a break. Adnan, thanks very much for joining me.
Assalamu alaikum.
Walaikum assalam wa rahmatullahi wa barakatuh. So this case, for some people, we know that the Wembley Masjid case, or the parties are, I think, Bahmani and others versus Sattar and others. That's the legal title of the case, the Court of Appeal decision. Tell us about this case briefly. I mean, we don't want to mention the specifics of what's before the High Court at the moment because the case is ongoing. But what's the essential legal principle that was in play when this case was recently, you dealt with this case with the help of a barrister in the Court of Appeal?
That's right. It's a historic case. It's been running now for about 2 years. But without going into the specifics of what's actually before the High Court, what this case, Bahmani and others versus Sattar and others, is a Court of Appeal case. And what it related to was a simple principle which the court were invited to determine, which is basically, can trustees, charitable trustees, whether they're management executives of a charity, can they seek to exclude anyone from entering a charity premises? So in this particular case, it related to a masjid, Wembley Central Masjid, which is a charitable organization. And the circumstances were such as that some...
Before you go further, just a quick question. So effectively, a charity that is running a youth club, a charity that's running a daycare center, a mosque, a temple, a synagogue, whatever. The argument that was being run against your clients was that as the trustees, we basically can decide who can come here and who can't come here. Is that what was being said by your opponents?
Yes. So just to be clear, I didn't represent the charity trustees. I represented the actual worshippers of the masjid.
Some worshippers of the mosque.
Some worshippers. So some select worshippers who were hand-picked or hand-selected by the charitable trustees, who they were seeking to exclude from entering the charity premises. So the Court of Appeal judgment establishes a principle which has an effect on all charities, effectively. And the example you give of like YMCA or other charitable organizations, it's yet to be seen how far this judgment can affect those organizations. But the principle is that as a matter of right, do charitable trustees have an absolute and unfettered right to stop anyone from entering charity premises? So, for example, like you mentioned, if it's a temple or a synagogue or a mosque or even a church, which is set up as a charitable organization, if they seek to exclude an individual worshipper from entering, do they have an absolute right, regardless of reason, to stop that person from entering as a matter of property law?
And what did the court say in this respect?
In a nutshell, the court said, in a sense, no. But no charitable trustee can exercise a right to exclude without having due regard to their obligations as a charitable trustee, and without having...
What does that mean?
What it means. So let's say, for example, you run a charitable organization, and I wish to come along and enter as a regular attendee, and one day you decide, Adnan, I don't like you. I don't want you to. You're not allowed to come in. As a matter of right, you do have that right to exclude me, but the charity which you represent, every charity is set up with certain rules. It has what's known as a constitution. The constitution is like a governing document which lays the foundation of exactly why that charity has been established. So like a company will have articles of association or memorandum of association. Those set out the rules, the guidebook of how the charity or the company is to be operated. And all charities are set up with certain objects, meaning that they have a purpose.
Their purpose, what they want to achieve.
Yeah, and those purposes have to be charitable purposes. So in this context, where you had a mosque, its charitable purpose was to provide religious services for the benefit of the community which attends or is within that vicinity. So every person.
One question for you. Sorry to interrupt. I mean, you said if the trustees want to exclude somebody, but let's say there are people who the trustees think are making trouble.
Yes.
trouble needs to be defined, but there's some disagreements, there's some debates, there's discussions. What must somebody do to be, you said they can't exclude somebody absolutely. So what would a trustee have to prove or be satisfied of to exclude somebody from a mosque or a temple or whatever it might be, a charitable organization?
Well, the general principle is that the exclusion has to be in the best interests of the charity. So if somebody is going to be coming in and disturbing prayers, or is going to be causing a nuisance, being a mischief, shouting abuse, screaming profanities within the confines of the mosque.
Well, as a one-off, would a one-off conduct on a one-off occasion, doing it once alone, would that be sufficient, do you think?
Well, it's a difficult case to answer because every case will depend upon its facts. If somebody has a history of abuse, then obviously the charitable trustees are well grounded to exclude that person because they're causing a nuisance. Yeah, they would have to be proven. Just because somebody asserts it doesn't mean that it's a proven fact. That's a matter for, if it goes to court, for a court judge to deal with ascertain the truth of it. But if someone is causing a nuisance, then the charitable trustees are permitted to prevent that person from entering if it's in the best interest of the charity. If they say, I don't like you because you're wearing a blue suit, yeah, we don't like blue suits in this charity, then can't be said to be in the best interest of the charity. That's somebody just acting what we call in law ultra vires. They're acting outside of their powers. That's what the Court of Appeal has said is not.
Okay, and I'm assuming that charities or charitable organizations then must publish. I mean, reading a constitution is kind of drab and boring, the sort of thing that lawyers will want to do, solicitors, barristers, but there must be some simple rules or some way of telling people, what's allowed, what's not allowed, what you can't do, what you can do, what you must do. So is there a requirement or at least a need for charitable trustees to publicize any of this sort of information so everybody knows, here are the rules, and I know what I can't do, what I can do?
Quite right. And it's a matter of good practice, in fact. You're right. No attendee of a mosque or a temple or any other religious organization or charitable organization is necessarily going to read the rule book or the constitution. So that's really up for the charity trustees or its management executive to publicize in a very simple layman's language those rules which apply, which are effectively conditions of entry. So in normal circumstances, what you will have is conditions of entry on a notice board, either on the door or immediately as you enter the premises, which explains if you enter these premises, you agree to abide by certain conditions, i.e., you're not going to grab the microphone off the preacher and start singing your own songs. You're not going to cause a nuisance. You're not, etc., etc. A whole host of rules and guidance can be laid down, and that's a condition of entry. Someone is obliged there by placing their foot inside. They are agreeing to abide by those conditions. But obviously, each one of those conditions has to be assessed because, again, if the conditions say you're not allowed in wearing a blue suit, then is that in the best interest of the charity?
In terms of, so in your case, your clients were the people who were some of the congregation who the trustees deemed to be unwelcome on the basis of the charitable purpose and objective of the charity. So as a charity, if a charity comes to you as a worshipper, you being the third person, somebody, and says, right, we're not going to let you in, we're going to ban you. What must they do to be able to ban you? What are they? They can't simply, throw you out. There must be some sort of process they have to follow or legal order or something they must get. I'm not talking about your specific case, but say, Joe Smith's charitable organization down in, I don't know, Harrow or wherever it might be.
Well, ordinarily in a case like that, if somebody is a nuisance, then what you do is they would serve some kind of a prohibition notice preventing them from entering. There's no hard and fast rule, but in terms of legal procedure, what they ought to do is go to a court and obtain what's called an injunction. An injunction is an order from a court which says you, Mr. X or Mrs. Y, is not allowed to do certain things. And that is a court order which carries with it a penal notice, meaning if somebody then breaches that, then there could be serious consequences for them.
Okay, and let's say so that happens. Can they get an order banning people from the charitable premises without the person knowing what the case is, or does that person have the right to then challenge it and go back to the court and say, look, actually, all of this is not true. I'm in fact the victim of some sort of witch hunt or something. Is there a way of challenging any such proceedings?
Well, essentially, somebody can obtain an injunction without the other party knowing, and that's called a ex parte without notice application. And that's only used in circumstances where, if you were to tell that person that you're applying to a court to stop them from doing something, they may then increase in their animosity and cause greater damage. But the case doesn't end there. If an injunction is granted, then usually you will always have a return date, meaning that it has to come back to court in order to allow that individual to have their voice heard. Justice has to be done. Just because one person has made an allegation doesn't make it true, and the court will have to hear evidence to decide the truth of the allegation. And if the allegation is disputed, then that's something which would go to a trial where live evidence would be heard, and a judge would then be better placed to decide the truth of the allegation.
So the judge has to decide who's truthful, who's lying, and if somebody has been naughty and broken the code of conduct. We were discussing earlier, I would imagine there has to be some sort of seriousness before you can exclude somebody permanently or temporarily. Can you say anything about that, or is it really very difficult to sort of give some hard and fast rules?
Well, an injunction, like I said, it's a court order which usually carries with it a penal notice, which means that if somebody breaches that injunction, then they could either face a penalty, a fine, or even imprisonment. So if someone has an injunction against them, it's extremely important for their own sake to make sure that they abide by its terms.
And get legal advice to understand it and to challenge it if need be.
Extremely important that they get legal advice, because if they don't, and they don't fully understand the terms of the injunction, they might inadvertently breach it and then find themselves dragged before the court in what are known as contempt proceedings.
Okay. And I mean, just on a final sort of question, because sometimes people can have disputes about how a place should be run, how it shouldn't be run. And what would you say to people who are watching, if they're in those sort of circumstances, if there are trustees faced with people who are causing them problems, or people who are attending and they see the trustees are not doing what they're supposed to do? How should they approach this? Because quite often trustees are not specialist lawyers, and neither is the average, Abdul John or Ram or whoever might be attending a religious establishment. What would you say to people like that before they get wade into these sort of disputes and discussions?
Well, it's extremely important that they seek proper legal advice. Trustees who are thinking about excluding individuals or anything else which may affect the general public which they serve, they ought to take legal advice to ensure what they are doing is, number one, in accordance with with the constitution of the charity, such that they don't do anything unconstitutional. Two, they don't do anything criminal. For example, manhandling somebody and stopping them from entering a premises without the assistance of the police could be a criminal offence. It could be an assault.
Battery and assault. Yeah, that's right.
That's right. And it's important that they seek legal advice early, because if they take the wrong action and they end up being served with proceedings against them, there could be huge costs implications, meaning that they might be ordered to pay legal costs to the other side who they've made, quote unquote, victimized. It could be disastrous for them.
And perhaps, a suggestion to try and avoid court proceedings altogether, try and resolve this through some sort of conciliation, mediation, because ultimately one would hope it would be an exception rather than the rule that places of religious worship, particularly, should become legal battlegrounds.
Of course. The last thing you want, and it's not very, very good for communities where you have legal disputes being, litigated on. It can create great schisms within the community. And it just increases animosity the more and more the proceedings continue. So yes, it's extremely important that mediation is used as a tool. You know, elders, you know, respectful people in the community or councillors, whoever it may be, are asked to mediate in order to reach a resolution without the need for legal proceedings. Legal proceedings should be the last resort.
Okay, well, thanks for staying there. We'll get Mr. Said back in and we can have a quick discussion. Saad, thanks very much for joining us again. I'm just going to make it a little bit more high. We go. That's nope. Let's try this. Yeah, that looks better. In terms of immigration proceedings, so we've spoken about nationality law and Shamima Begum and court proceedings. What advice would you give to people who potentially are concerned that they may have either deliberately or accidentally misstated or information in a visa application in the past, or are going to now apply for indefinite, before they actually make an application and end up being, you know, resolutely refused? What should people think about to try and correct a mistake or a wrong in the past, which wasn't picked up perhaps, but could come to light?
Yeah, that's a very, very good question. So obviously, having dealt with many of these cases now over the last few years, and having seen them become more prominent, given what the Court of Appeal said is the correct approach to be followed, given the way that the law has developed over the last couple of years, it's very, very important that if anybody has behaved in this way, they seek legal advice before they make their application, and well in advance of making their application, because as with anything, there is always a scale. There is a category of people who are definitely going to fall foul of the rule. There is definitely going to be a category of people who won't fall foul of the rule, and there's going to be that category in the middle. And everybody needs to know where exactly they may stand. It's very, very important for their own future so they can plan it, because a lot of people have spent a number of years in the UK only to be refused under this power by the Home Office and decided to give in and maybe not fight their case legally and up and leave the UK and return to their home countries, having spent a vast majority of their adult life in the UK, having studied here, having got good jobs and things like that. So I'm sure some of the people that decided to leave and return to their countries may have had a good legal case if they had been advised or sought legal advice as well, especially the way the laws have been developed over the last few years. So yeah, very, very important. Anybody who thinks that they think they may fall foul of this, or anybody generally, seek legal advice, because there are also other pitfalls, as we're all aware of, that may catch them out. And as lawyers, any specialist in immigration law is able to check that and make sure whether, you know, everything is going to be okay, whether there will be any pitfalls.
I mean, the law, immigration law is it changes more often than the British weather does very often, and the difficulty for people whose first language is not English, and even for people whose first language is English, I mean, even we struggle sometimes. I was reading the Shamima Begum judgment, and then the way that the law has changed over the decades since SIAC first came into existence 23 years ago, it's very difficult to keep up to date with. So what would you say is if people are approaching a landmark where there's 5 years lawful residence to apply or 10 years lawful residence, would you say that they should seek early advice? Because you would need to presumably look at the documents, ask the tough questions that need to be asked, so that you can say, well, you know what, you really have got a problem here, and this is how you can try and fix it, rather than turning up and saying, well, I'm applying next month, what can you do for me now?
Yeah, that is definitely the case, that the earlier one seeks legal advice, the better it is. And even sometimes if you seek legal advice 6 months or a year in advance of when you're actually going to be making your next application, that can also be beneficial. because sometimes it may take a few months to remedy any defects or any potential pitfalls which may be arising in the future. Or it's important even to try and see what may be coming over the horizon when you do apply. And you can only do that if you do get proper legal advice from a specialist.
And people will say, well, look, sometimes when they hear about Court of Appeal, they'll think, oh my God, how can I afford it? Is it possible to try and sort of reasonably predict? You can't, give a final figure until you know where the case will end. That's clear. But certainly stage by stage, would you be able to say to somebody, well, look, for this stage, it will cost you this much. For this stage, it will cost you that much. So people are going to have at least a degree of confidence that they're not going to be thrown a 5-figure bill when they were expecting a low 4-figure bill or a 3-figure bill, for example.
Yeah, I mean, you're exactly right. You say that we can at all times try to assess stage by stage what the costs are likely to be. I mean, we're not going to be precise and exact because there's so many unknown factors as well. And the ultimate goal is by seeking early legal advice, you won't have to go through all of those stages. You may only have to go through 1 or possibly 2 stages. But yes, definitely, if you go to a specialist who's well experienced in going through all of the courts and the higher courts, even up to the Supreme Court, they'll have the knowledge and be able to give you proper estimates as to the costs that may be involved.
Thanks for that. Adnan, coming to you, I mean, increasingly one hears that there are more and more charitable proceedings or charity-related proceedings, should I say, in the courts. And in terms of trustees trying to get things right, because many times there will be troublemakers who are members of the congregation, and often a time there'll be troublemakers who are trustees. What would you say to anybody who is aggrieved in terms of, you touched upon it earlier on, but again, when they think, well, you know what, the High Court, injunctions, this is the sort of stuff that movie stars and royalty, Meghan Markle's and people like that do, because it's very expensive. Again, costs, can you sort of provide a similar sort of framework as the start was saying about immigration legal proceedings, so that people can at least have a stage by stage sort of budget and pursue proceedings like that?
Yes, it's difficult to provide just like a ballpark figure because each case is different. For example, in this particular case, the Court of Appeal Bomani case, there was, a total of 14 defendants, and whereas it really depends on the number of parties that are involved. What I meant
was, once somebody comes to see you and you get to use common parlance, a good handle on what's going on, get an idea of the case, you can then say, well, look, for this stage, it'll cost you this much, I estimate, and these will be the court fees. And obviously, nobody can give a final figure. In terms of charitable proceedings, because many people will ask, if it's a charity, do you need the charity commission's permission to bring proceedings if you want to start some charity proceedings? First question there, is this something which is required, or can you just simply launch into proceedings without any permission if you want to take proceedings, that is?
Okay, well that's something also which was deliberated on by the Court of Appeal in this case. But as a starting position, Section 115 of the Charities Act 2011 sets out clearly that any charity, anyone who seeks to bring charitable proceedings, which come within the definition of charity proceedings, must seek the permission of the Charity Commission or get permission from a High Court judge. In normal circumstances, someone would go to the Charity Commission, seek their approval. And the reason for this is because a charity operates using public money. And public money can't just be, spent freely upon legal proceedings. So it's extremely important that the Charity Commission first give the thumbs up and say that this case warrants legal proceedings. But most of the time, the Charity Commission will feel that they might be able to make a decision on it without the need for legal proceedings. And in those circumstances, they may not give permission and, in fact, intervene themselves. Where they feel that they can't, for example, there's a case which involves a substantial dispute of facts between the parties, one party saying one party saying one thing, another saying another, Charity Commission can't really decide upon that. In those circumstances, normally they would say, well, this is something which maybe the court should consider, and then they would grant permission. But nobody can bring charity proceedings without having authorization from the Charity Commission first. And in fact, I know one case which I myself was involved in, where proceedings were brought by an individual which constituted charity proceedings, and when that was drawn to the attention of the court simply said, right, and we're going to have to put this case on hold, go and get the permission from the Charity Commission first. And that individual was ordered to pay a substantial amount in legal costs for having brought the proceedings that far. So it can be, very, very costly for somebody to take that step without getting authorization first.
In that case, was he legally represented? I mean, we don't even mention the name of the solicitor or the firm if he was, but was he legally represented?
He was legally represented by
don't mention the name.
I won't mention, but he was legally represented by a lawyer who wasn't a specialist within charity law, and not having a grip on charity law meant that he was completely ill-advised about Section 115, and ended up having to pay a substantial amount of legal costs.
Okay, and obviously with what we are concerned with today, principally, if you are the victim of or if you are subject to an injunction, then that's not necessarily that's not charity proceedings. Is that right? So if you've got somebody turns up at your door and says, "There you go, Mr. Mahmood, you can't come to the mosque from now on because you've been a bad boy," you can obviously defend proceedings. You don't need permission to defend proceedings. It's only if you're bringing them in the name of the charity or they're linked to charity. Correct?
Quite right. It's an issue of bringing proceedings. So if you're a claimant, or if you're a charity trustee or whatever, and you're the one bringing the proceedings, if the proceedings which you're bringing come within the definition of charity proceedings, then you would need the permission of the court. In fact, I'd like to see.
Or the Charities Commission.
Yeah. In fact, it was the judge in this particular case. I've just got the judgment in front of me, but Justice Nugi, he actually made this point quite clear. He says, "I see no reason referring to the defendants why they should not be able to raise as a defence the claim of an allegation in the proceeding." Sorry, I've just lost the exact reference. But
take your time.
But what he specifically said. Gosh, you made a very good point, but I can't seem to find it now. You
read that. I'll ask Saad one last question,
okay,
and then I'll come back to you. So, Saad, in terms of we've spoken about this paragraph 322, general grounds of refusal. Now, if you have gone to a lawyer and you realize, you know what, my lawyer doesn't really know what they're doing, what would you recommend to somebody like that? Because sometimes people might think, well, I'm trapped here. I've spent a lot of money. I might just take my chances. Is this a wise policy? Because I've had people come to me when you sort of put your head in your hands and think, why in the world did you not find somebody else when you realize that this happened, for example?
Yeah. I mean, look, we say it time and time again on this live stream that prevention is always better than cure. And that also applies at the time when you are early on in your application or in your legal proceedings, in terms of instructing your lawyer or your solicitor or your consultant, whoever it is. If at any point you realize or you think this person is not a specialist and I'm not being advised properly, regardless of what stage your case is at, always better to find somebody else who is a specialist rather than continuing with the same person. Because, I mean, me and you have dealt with many cases, as you said, where people have gone all the way through their proceedings with somebody who may not be specializing in a particular area of law, and having lost the case, when they go to another solicitor who is a specialist, and that solicitor always identifies problems in the way things have been conducted and in the way the case has been handled and in the way it was run and put forward. And they always have the opinion, well, look, if you'd done things differently right from the beginning or even halfway through, you would have stood more of a more of a chance than coming to me when everything is finished. And unfortunately, when you're in that situation, it costs more to try and unravel all the mistakes which have happened in the past than it would have if you'd left earlier and find somebody at an earlier stage who knew what they're talking about.
Thank you. Aman, coming back to you then, I'm assuming you found your paragraph reference.
I have, yes. So the point that you were asking was if someone is served with, if someone finds themselves, having a legal claim brought against them, by them defending and raising sort of an argument that these are charity proceedings, does that mean that they need to first ask the Charity Commission to give them permission in order to defend that claim? That was a point that was raised in these proceedings, and Justice Nugi said it quite clearly that bringing proceedings is always a voluntary act, being sued is not. And in general, there is nothing wrong with a person who finds that he is sued seeking to defend himself. So essentially what that means is that if you are bringing proceedings seeking to assert a charitable right, for example, then you would need it's for that person to get the Charity Commission approval. But if you're served with a claim, and it's alleged that you're, for example, you're excluded from the mosque, and you then say, no, hang on a second, you can't exclude me without actually, putting into the mix your obligations as a charitable trustee, that may come under the definition of charity proceedings, but that doesn't mean that you need to go to the Charity Commission to get approval first. That in itself would be, as Justice Nugi pointed out, in itself would be a breach of your right to a fair trial under Article 6 of the European Convention on Human Rights, although that's may not no longer be applicable.
It does apply. It does apply.
Yes.
Still applies.
So in a nutshell, you don't need it's against the rules of fairness and justice for you to ask somebody for permission in order to defend yourself. It just doesn't make sense.
Indeed. Well, look, thanks very much, both of you, for giving us your wisdom on both Court of Appeal cases. Yours settled without a fight, Saad, yours, Adnan, went all the way to the wire, and thankfully for your clients, you came out on top. So thank you very much for watching. As ever, we always say prevention is better than cure. Take professional legal advice, whatever the area of law, whatever the legal problem, no matter how trivial or difficult it may seem, to make sure you try and get it right. And just before we leave, I'm going to just play a short video so that we can all understand that before we say goodbye. Assalamu alaikum and goodbye from me and from my guests. So.
Assalamu alaikum.